started. So
Yes.
we are tuned in to the Boss Woman Network podcast. I have Miss LaShaila Spivey.
LaShaila.
LaShaila?
LaShaila. Yep.
LaShaila Spivey. Is that correct?
Yeah. Yes.
All right, LaShaila, tell us a little bit about you, who you are, and what you do.
Yes. Thank you first for having me. So as you mentioned, my name is LaShaila. I am a trademark and business attorney. So I work honestly a lot with women entrepreneurs, helping them protect their intellectual property, primarily trademarks. I help with contracts, some entity formation as well. So I work, primarily with a lot of startup clients, a lot of small business owners, and again, a lot of women owned businesses.
So you're all about women empowerment, I see. 'Cause you
Absolutely.
So how did you get into this? I mean, when you graduated high school, did you go straight into law?
Yep, exactly. So I always knew I wanted to be a lawyer, but honestly, when I was younger, I thought I wanted to do like criminal defense work or, do something with the criminal justice system. When I was in high school, I actually took a graphic design course. And I remember being in the room with people who, they're like, I want to be a videographer, I want to be an interior designer. And I'm like, I want to be a lawyer. I didn't know how to make it kind of gel. And I remember my high school teacher, she said, you could be a copyright attorney. And I'm like, I literally had no idea what that
Hmm.
was. I'm first generation everything, first generation high school, college, law school. So I honestly had no idea what it was. And she was, telling me a little bit about it. And honestly, at the time, I was like, okay, that sounds like something. But sure enough, I graduated from high school. I went on to Indiana University, Bloomington, graduated from there, and went straight to Indiana University again, the Maurer School of Law for law school, and I got involved in our intellectual property clinic. And so it really happened. I was, very much interested. I feel like intellectual property is one of the most fascinating areas of law because it's one of those areas where we all can relate. We may not know what it's called, but we've all watched a movie. We all have a favorite song. We all have a favorite brand. So I think it's one of those areas of law where, again, it's really easy to relate to. And so, yeah, from law school, I started helping, again, small business owners protect their intellectual property by, filing trademark applications. And so, right out of law school, I worked for a very large law firm doing intellectual property work. So it's definitely stuck. I'm really passionate about it. I think one of the things that's changed since I graduated from law school in 2019 is just the method for practicing intellectual property law. So, like I mentioned, I was, previously working for a really large law firm. So my clients were really large companies, and I really, enjoyed the work. It was challenging, but there was a disconnect. I feel like I was doing a disservice to my community. A lot of the enforcement side of intellectual property, so writing those cease and desist letters, I noticed that overwhelmingly a lot of the people who were on the receiving end of those letters were small business owners, people who honestly had no idea about the rules of intellectual property or the rights that they're afforded as well. And so, during the height of COVID, I left my firm, I resigned, and I started my own firm. And I've been able to connect with, my community and more of my target audience. And again, really trying to shift the balance, taking people from uninformed to empowered and educated about these topics, leveling the playing field, so to speak.
I love that. So what made you focus so much on the women's side?
I feel like growing up, I had so many family members and, friends who were starting a business. I feel like a lot of times, as women, I don't have kids, but I know, a lot of people, because they're trying to take care of their children, their family, they start businesses. And so, I've always been, super proud seeing women, starting their own and making their own lane. I know a lot of women have started their own business because they face like workplace discrimination or because of their schedules, they can't, work and afford childcare and do all those things. So I felt like there was a greater need. And I feel like, women are already so bossy. We're on it. I think it's just one of those things where once you're introduced to it, now you know to look out for it. And again, with even after COVID, women, we were just starting businesses left and right. And I was like, I want to help them create something that's long term. Um, because if you don't take these steps at the forefront, what I have found is a lot of people, once they built something, they've scaled it up really big, they're getting that recognition. That's typically when things go wrong. That's typically when, now you're on someone's radar and they're like, oh, hey, actually, that sounds like my tagline, or that looks like my
Right.
logo. And
Right.
so now you have problems and it's good. You're making money. There's that visibility, but you risk losing that connection. If you lose your social media handles, if you lose your domain name, all of those things because they run afoul of intellectual property rules. It's a lot to lose. And honestly, small business owners are not equipped to handle those type of blows. It can quite literally, bankrupt someone's business
Right.
if they do have these issues. So it's really important for me to do what I can to at least be, that first step and kind of, guide you, hey, you can't use this big company's, logo or similar, color schemes with what you have going on here. There could be some confusion. They could have an actionable claim. A lot of people don't even know that part of it. Like, what do you mean I was inspired? Or, what
Right.
do you mean I changed a letter or I did this? So many people just don't, again, they don't understand the legal framework behind it, which there's, a lot of different things related to law that a typical person may not understand. And so that's where I add value, and I, help my clients, guide them through that process. But also, even, it doesn't have to be that, hey, you've been in business for 5 years, 10 years, and now you're thinking about it. You can say, hey, for example, I've already, I have this existing coaching business, but I'm thinking about, having a signature course and I'm thinking about calling it this. Like, let's talk about it. Let's do some searches and make sure no one has something, close to that where before you know it, you're, getting hit with a cease and desist before you launch or after you launch, which is honestly worse. So yeah, helping them navigate those issues is really important.
I love that. So, for instance, because I know trademarking is very important, and a lot of us don't understand how important that is.
Yeah.
So, for example, someone has a company called the Best Practice Podcast, and then someone else has the Best Practice Shoe Store. Is that an issue? And if it is, how can explain how that would be a problem?
Yeah, that's a really good question. So, unfortunately, and the lawyer answer is it depends. And what it depends on there is it will really depend on what's already registered. So, and it brings me into another important topic. We talk a lot about, secure your registrations, get your trademarks. The other side of it is you have to enforce it. So, let's say, for example, you have the best practice podcast. And you enforce it really well. So no one has the best practice anything. Now, if someone comes with, something that's slightly different, you have a stronger position to say, hey, no, this is confusingly similar. There are some industries and some words that people use where we say, hey, it's pretty overcrowded. So it's harder for you to say, I have the exclusive rights over this. So I think about with trying to think with like hair companies, for example, a lot of hair companies will use like luxury this or lux this,
Right.
like certain words depending on what industry they're used in. It's like there's already so many using that. You can register the mark, but you're not going to be able to be upset if you see something that's slightly different. If you know going into it, hey, there's already so many the best practice podcasts. They just have a slight variation. Of course, no one can use your exact wording, but again, that's something where I help clients, manage their expectations because some people are very like, hey, I don't want anyone using anything similar. Well, hey, let's come up with something a bit more distinctive because what it currently looks like is that there's already a lot of existing companies. We can, put something out there that isn't conflicting. But if your idea is, hey, I want to own all of this, I don't want anyone to come anywhere, close to it, you're going to have to pick something that's really distinctive in that, when we're doing our searches, we're not seeing, really anything similar at all. That's going to put you in a stronger position.
So do you have to register your business in all of the classes in order to keep someone from using it?
So yes and no. You do want to register your business in all of the relevant classes. However, the trademark applications, they are by class. So if you have a podcast and you also sell t-shirts, for example, for your podcast, those are going to be two separate classes. Now, if a client came to me and said, hey, I have a podcast, I'm also selling merchandise, I'm tight on my budget, I would say, hey, let's hold off on the apparel for now. If assuming your podcast is your bread and butter, it's what's bringing in, business, it's the highlight of your brand. We might pause and you can, file for that later. And that's totally fine. I think a lot of clients, they think I have to do everything all at once. You want to make sure that you're adequately protecting your business. And, sometimes your services or your goods don't nicely just fit in one class. So for strategic purposes, it makes sense to do both. But again, for budget restrictions, we can do what's most important. And then later on, maybe once we get some more revenue coming in, or, we're expanding even more, we can go ahead and apply for those additional classes at a later time.
This is such an important topic because I run across people all the time that have struggles with trademarks. So I have another question for you, kind of
Yeah.
similar to the first one. I had some women that I knew that were having a conflict. Both of them were using, I'm gonna just make up a name because I don't want to use their, put them out there like that, but both of them were using, let's try the best practice again. But one of them was using it first, but they're both
Hmm.
doing events. But one of them had the name first and was doing the events, and then the other one decided that they were going to do the same thing and was doing events. But then when
Hmm.
it was time to trademark, it was already another company out there that was using a portion of the name for events. Does that mean they could not register it at all or just could use it in a different class in some type of way?
So, and again, it's going to depend, but let's say, for example, and what's important is when you apply for an application, I'm sorry, when you apply to register your trademark, there is going to be a trademark attorney that works for the government sitting on the other side, and they have their rule book of what can be registered and what cannot. So it sounds like in this situation, what would happen, let's say, um, event person one, they went to register it. More than likely, that prior registration would be cited against their application. So they would issue what's called an office action and say, hey, we can't register this because we see something that's confusingly similar under Section 2D of the Lanham Act. So they're called 2D refusals. Um, we see something, they'll list the registration. And at that point, if they're able to register, it really depends on a lot of different factors. But some things that I would look at are, one, let's really look at what this other company's use really is. Let's really hone down are they really using it for identical services or is it really something completely different? And then what did they put in their application? What did they say? Because you have to say how long you've been using it or when you began using it. So I would recommend like let's look at that. So it would depend. I've been in a similar situation and I've been able to, get my clients mark registered, but it really depends on all those factors. So, for example, if I look and I see, hey, this is a well-established brand, they've been using this since, 1999, they've been hosting, conferences all over the world. My recommendations will be a lot different than, hey, it looks like they just registered this. They haven't even started using it yet. And it looks like they've only held one conference in Idaho. My recommendations and our strategy moving forward will be really different. So those are just really fact specific determinations. But it gets murky really quickly. And so the faster that you can say, hey, I have this brand, I want to protect it, and you jump on it, the better position you're going to be in. Because what happens, even in the situation we're discussing, even if, let's say, one of those companies really did have superior rights, they've been using it for longer. Unfortunately, what can happen is now you're in a position where you have to go spend money and time and resources to, get that registration, to reach out to the other party. Um, they've essentially beat you to the punch, and not saying there's no recourse, but normally it's going to take you a lot of time and money, and that's something that a lot of small business owners don't have.
Mm,
So I've seen people lose their brands that way, even if you
wow.
are technically right. Yeah, exactly. So it's it's one of those things. I think a lot of times people say, you hear trademark attorneys like, go register, go register. I will honestly say a trademark registration doesn't make sense for every business, depending on, where you are in your business journey, what products or services you're selling, what your future plans are, a host of other things. But overwhelmingly, it's much cheaper to register the trademark than to try to fight for it later if someone else, snatches it up. I also want to note that Here in the United States, our system is on a first to use basis. So we've been talking about, who was the first to use it, who was the first to use it, which again, that's our standard here in the United States. In other countries, they run on a first to file system. So if someone beats you down to the trademark office, they're in a better position than you are. Here in the United States, that's not true. We do go on first use. However, the trademark office, let's say, you and I have businesses with similar names. You register your mark today on March 25th. And you registered on March 25th and you say, I've been using it since March 25th. I registered on March 26th and I say, I've been using it since 1986. They're going to register, I'm sorry, they're going to review your application first because you filed first. It doesn't mean that you have prior rights, but it's more of a systems process.
Mhm.
A trademark attorney isn't going to say, hey, I see two people registered, this one's saying 86. No, they're going to say March 25th, this one came in. And what would happen is if I filed a day late, they would examine yours first and they would get to mine and say, hey, Leilani already has something out here. We're going to see what happens with her mark first, and then we'll get back to you. And so now you're in that position where it's like, even though you filed, you still are going to have more, time delays and, figuring out this other company. Are they going to get the registration first? What are they going to do with it? Am
Wow.
I going to have to, initiate a lawsuit? Obviously, we wouldn't go straight to a lawsuit, but those type of things are, real consequences for someone, beating you to the trademark office by a day, even though here our rights are construed differently. Again, it just puts you in a position where you'd have to pretty much argue that by initiating some type of lawsuit, either, formally in court or through the trademark office, which is the Trademark Trial and Appeal Board, the TTAB. It functions, very similar to our real court system. Again, super costly, super time consuming. You definitely won't be enjoying the day-to-day operations of your business
Wow.
if you end up in a situation like this, unfortunately.
Wow. So what if one person is a book company and another one is clothing, but they have the same name? Could they still register then? One is selling books, one is selling clothes.
Yeah, exactly. And we have some examples of that. For example, we have Delta Airlines and we have Delta Faucet Company. They coexist, they're fine. We have Dove for body care, and we have Dove chocolates. They coexist, they're fine. So
Okay.
we have, lots of examples of two marks with the similar or same name. Pandora for, music streaming and jewelry. They coexist. So lots of different opportunities to coexist depending on if the goods are truly, not similar. And if, I think what's also important to remember, trademark rights are really derived from wanting to protect consumers. So it's not, hey, we want Nike to be able to have this prestigious brand. That's definitely some of what's associated with it. But the reason why these have been, these rules are enacted in federal law are because we want to protect consumers. We want you, when you, buy a sandwich from McDonald's, we want you to know you can trust the, brand names on it. And maybe you're not getting a sandwich from McDowell's instead and you got confused, you
Yeah.
didn't know. So, that's the reasoning behind it. So, if the goods are not that similar, if the services are not that similar, you can, and we see that brands can coexist.
That is.
Um, yep. And sometimes you do have to show that to the USPTO. You have to say, hey, we've agreed, this person isn't going to sell on Amazon, for example, or this person isn't going to, sell to this demographic. This is how we're going to make sure there's no consumer confusion. Sometimes it may just not be possible, especially now with the internet. It's really hard for us to segment ourselves.
Right.
We definitely can get creative and, find those restrictions on how can we make sure, people aren't going to get confused, and to make sure, hey, you're, keeping what you've built, I'm keeping what I've built. Hey, if someone comes to me saying, hey, are you, Delta Faucet and I'm selling airline tickets, I'll redirect them to, to that.
Right.
Um, but and you honestly, you have to say, hey, that's what we're going to do, to convince the trademark office that, hey, there really isn't going to be any consumer confusion. So
Oh,
uh yeah, it really gets drawn out. And so I think that is why the easier way is just, if you got something and you think you want to use it or you are using it, go ahead and register it, or go ahead and, at least frame that process out and think, what is this going to look like? You don't have to actually use the mark before you can apply for it. So, if tonight you say, oh my God, this will be a great, name for a coffee shop, you can apply for it and you can say, hey, hey, trademark office, I haven't used it yet. They'll give you time, they'll check in essentially every 6 months and say, hey, have you used it yet? And you'll have to, keep, filing and paying fees to, draw that process out before they finally say, hey, you haven't, shown us use, you got to go. It takes about 3.5 years for that to happen.
Wow.
But now imagine if you're waiting on someone to show use for 3.5 years and you've been using your mark, but you
I
filed later
know.
than
Oh,
them.
that would be stressful.
Yeah, they can. And again, a lot of times clients don't know just how long of a process this can be. It's already going to be, a 13-month process. And that's if everything goes swimmingly. Now, add in office actions, add in those type of things happening. It can, really delay your process to, officially obtaining that registration.
Wow. So do you recommend trademarking the name or the logo or both?
That's a really great question. Again, it depends. If you have budget constraints, I would recommend your brand name first. That is typically what's going to withstand the test of time. With logos, typically people will change, the colors
Right.
or maybe even the logo all in and of all of itself. So I recommend brand name first. And then if you um, Okay, there we go. If you have additional, budget, let's go ahead and do the logo as well. And those will be separate applications as well.
Oh, okay. That's good to know because I know these are questions that a lot of people have as far as
Yeah.
trademarking. These are like major stressful because I saw something online where a guy was giving out information and he was saying it's better to trademark your logo because if you trademark your logo, then you're trademarking your name and your logo at the same time, and that's not true.
And so it's not true. And so this is
Mm,
when you apply to register. I'm going to actually real life. So this is Sally Hansen Instant Cuticle Remover. So when you apply for an application, let's say the Sally Hansen, I mean, it is a stylized logo. It's words, but it's still a stylized logo. So if you apply to register just the stylized logo along with the words Instant Cuticle Remover, you would have to use that every single time. So Sally Hansen, obviously is using this brand name separate from the instant cuticle remover. So that's
right.
why you want to register them separately.
That makes
Um,
sense.
and it's because even if you do register, if you see McDonald's and you see the golden arches on one application, you have to use it like that every single time in
Mm,
order for it to be protected. If you're using part of it and not all of it, that's technically not what your registration covers. And so that's why we recommend splitting it up. So if you do have budget constraints, go with your name first. Um, again, your logo, I'm not saying it's not important. It certainly is important. And depending on what business you're in, I mean, if you have a really distinctive logo, but your brand name is, maybe it's just your personal, your personal name, I might recommend, hey, let's get the logo first instead of the brand name in this instance. Again, it's really going to always just depend on, what your goals are and what you have going on, how you're using your mark. It's really good to, talk to an attorney, lay it all out so we can really advise you. I know that the trademark office has made it the layout, at least for the application, it's really user friendly. It seems like, hey, I can do this. And a lot of people DIY their applications. No shade, no shame to those people because you have to do what you have to do. But it is a legal process. And, if there's going to be an attorney reviewing your application, it only makes sense to have another attorney on your side as well, guiding you through that process.
that makes sense. So, question: if you have, for instance, a business here in Houston and they haven't trademarked it, but some company that has trademarked that particular name somewhere else, can they shut your business down if you haven't trademarked it?
Essentially, yes. So
Wow.
what will happen? You have a business in Houston, you haven't registered your trademark, but someone else has registered it with the USPTO, which is going to give them, broad coverage. That gives you, recognition throughout the United States. They could and it depends on what evidence you have as that Houston business owner, what you can pull out. What we typically see is you would then probably be constrained to your town in Houston, maybe the city of Houston if you're lucky, but you wouldn't be able to sell across state lines if that other person has come. And again, it depends if this person is really litigious, if they're like absolutely not, they could really make things really bad for you.
Wow.
Yeah, exactly. There is a restaurant called Burger King that is in Kentucky, I believe, and this type of thing happened. The small company in Kentucky, I believe, they didn't register the name. Burger King, the chain as we know it, they registered the name, and so that company now only operates in a small town in Kentucky. And it's
Wow.
because yeah, they technically were first, but you're gonna have really, really narrow rights if you're only relying on your common law rights and someone else comes in and they establish that worldwide use. You know, you could very much be limited, or you're gonna be in for a really intense battle, you know, for those rights.
Wow, that's some very helpful information. So, do you work with people from the music industry as well?
Um, Currently not as much, but previously I did represent record labels when I did a lot more like copyright work.
Mm.
But now individual, you know, you can still work with, you know, individual entertainers, not as much now in the trademark space, but you know, entertainers, I also recommend, you know, trademark your business name, trademark your, you know, stage name. You definitely can do those things as well.
Wow, trademark your artist name.
Absolutely, absolutely. SZA has hers registered. Kendrick Lamar has registered his name as well. Taylor Swift, she has a huge portfolio, a trademark portfolio. You know, honestly, I feel inspired now. I want to, you know, show some of the trademark registrations that entertainers have. I think people forget that even in the entertainment industry, why it primarily does focus on copyright law, trademarks are still super important there as well too.
Wow, I didn't know that they were
Yeah.
trademarking their name.
Oh, absolutely, absolutely. You may have seen in the news recently, you know, Kim Kardashian and Kanye West, they
Oh, I
have
did.
registration for Northwest's name. Beyonce has registered, and Beyonce had a really long battle registering Blue Ivy because there was an existing company with that name. It was, you know, an extremely long trademark battle, and they finally got it registered.
Oh, so she was
Again,
still able to get it registered.
she was able to get it registered, but I want to highlight that this is coming from, you know, Beyonce's legal pockets are a
Oh,
lot different than the, you know, average person.
oh, she was
Yeah,
able to make it
exactly.
happen.
Right, exactly. Most people couldn't, you know, afford to be in a lawsuit for 12 months, let alone, I think, well, Blue Ivy's like what, 12 or 13 now. So it
Yeah,
was a long, long fight. Again, if you don't have those type of pockets, totally understandable, but that's why you do it as soon as possible.
as soon as
It's going to
possible.
put you in a better position because a lot of large companies, they're going to do their due diligence typically and see what's out there. And when you come across those registrations, you know, it causes you to pause. Now, I'll be honest, some companies they have the budget to say, hey, you know, maybe we do just see it's this small company. We can afford to pay out if we do get hit with a lawsuit or whatever negativity comes their way. A lot of small business owners, you know, we just don't have the budget for that. We can't take that type of blowback. So,
Right.
you know, it just makes all the more sense to go ahead and do that on the, you know, do it before you have to, because
Do it
once
before
you
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 answer.
want to rely on your trademark rights, you're not going to want to have this super long battle, this super costly battle. It's honestly it's exhausting and it's going to take you away from running your business. I reckon if you wanted to be a trademark lawyer, you would do that. You don't, so that's why you started whatever, you know, business. I want to keep my clients in their business. Your day is best spent, you know, working with your customers, working on marketing, you know, your product, your service, not trademarks and figuring out, you know, where you stand, what your rights are. That's what you hire me for. And I can help you, you know, with that entire process and, you know, really make sure you're covered and you're protected, especially before you launch. That's the best time to reach out to a trademark attorney before you launch. Let's make sure you're protected. I know it doesn't always happen that way, and that's totally fine. So your next best opportunity is immediately thereafter. So if you've
Right.
already launched, it's okay. Let's talk about it. Let's, you know, still assess that level of risk, if any, that you have. Um, and look out for anything that could come your way from either you using the mark or registering it. And I think people also forget those are two different things. So using a trademark is one thing, actually registering it with the USPTO is another thing. And sometimes someone who's been using the mark before you, they have different viewpoints on both of those. Some people don't want you to use it or register it. Some people are like, I don't care if you use it, but you're never going to get this registration.
Right.
So again, that helps formulate our strategy. And my advice to clients on, hey, if a registration is super important to you, it's not going to it's not going to happen. Let's move forward. Let's brainstorm some other names.
What about film, movies, things like that? Should they trademark the name of the movie?
So if the rules are a little bit different, but you absolutely you can if it's going to be a series, you definitely can register, your book titles, your film titles as a trademark. And I think that's important to talk about. Again, some components, especially when it deals with the entertainment industry, you have that level of copyright protection, but trademarks still play their role as well. So yeah, trademarks, I mean, any type of brand name, podcast name, your shoe line, your cosmetic line. If again, you're a coach, you have a course, all kinds of different things you can apply to, register that name, register that distinct logo, that color scheme that you have going on. You can apply to register those. And again, talking with an IP attorney is going to help you figure out what's most important to me. If you're selling a product, that trademark or service, that trademark protection is going to be paramount. Um, Copyright protection is a little different because it is instantaneous. So the moment you film a movie, write a script, record a song, write a poem, you have copyright protection. It's instantaneous. Registering the copyright definitely bolsters that protection, especially if you need to sue someone, where trademarks are, kind of different, where trademark rights do you just by using the mark, you have rights by using it. Registering it though is what is going to give you additional protection that you really do need if you're going to be operating a business.
Hmm. So what are the main services that you focus on? Is it just trademarking? Is that like your main thing?
Yep, that is my main thing. At first, I was doing a bit more copyright, but now I've really just honed in on all things trademark application and registration. Um, I help clients also with enforcing their trademarks, but more so for monitoring. I currently don't represent clients in, trademark infringement lawsuits or initiating a trademark infringement lawsuit. I have great trademark infringement litigators who I would be happy to, attorneys who I'd be happy to refer you to. But I am, all things start to finish from a trademark perspective. I also help clients, create contracts for their business as well,
Okay.
and review those as well too. I think it's great that more people are using contracts, but we have to make sure we review them and not just sign them. So, really informing clients like, hey, this is what you're actually signing is important. And then again, if you need to register an LLC, happy to do that as well. So I'm going to be kind of that first stop for you, when you're first getting started, but also too, if you've been in business for a while, and trademarks have been kind of in the back of your mind. I've helped clients who've, been in business for over 10 years, never applied for a trademark registration.
Wow. Okay.
Yeah, so I mean, all kinds, startups right before, never use the mark. I'm thinking about it to all the way. I've been using it for years and years and years and just never, solidified those rights.
So how does somebody find you that wants to use your services?
Yeah, that's a great question. So a little plug, if you can visit me at www.shylaw.com, SHAI law.com. I'm on Instagram as Attorney Shy. The last thing I will say, I am located physically in Indianapolis. The great thing about trademark law is that it's federal law, so your trademark attorney can be from wherever, as long as they're barred within the United States. So typically, if you needed someone to represent you, they'd have to be within your state. But the good thing about trademark and copyright law and federal law, period, is you can, work with people all over. So, follow me on Instagram or on TikTok. I post a lot of, content about trademarks that I hope is really useful for you guys. And I have a website. I, post blogs as well. So, reach out. If you have questions or if you're not sure if you need, official help, reach out anyway. And, maybe you don't, but maybe you do. So yeah.
I'm sure most of us need official help with that part because that has been a struggle for a lot of people. I've been speaking that's what made me want to, because I had posted a post on Threads and I was trying to find somebody that had information about trademarks to kind of help be able to have that on a podcast to share that information with people that's watching the show to learn because that is really serious. You really do need to have your company trademark, your podcast or whatever you're doing. That way somebody can't just come in and steal your business. I also heard that if your company got to a certain level and you want to go public or someone wants to buy your organization, your company needs to have the trademark on it, or they can't even buy it because somebody else may have the name.
Absolutely. I mean, if I was representing a client who wanted to acquire a business, and I have before, we're doing the due diligence on the IP. We're going to check it out. Do you own it? Have you kept up with it? So sometimes people apply for things, but they never submit any of the maintenance paperwork. Well, your application or registration is now, dead. So, is it still active? That can really increase or decrease the value, the overall value of your company. So, even from that perspective, if you ever hope to sell your company, and also remembering that intellectual property can be used as collateral. So you can use your registration as collateral to secure a loan. Again,
I did not know that.
That's going to be a conversation that you'll, want to talk about, and make sure you completely understand, what you're leveraging there. It's not as common, and typically it's going to be, a company that really has a lot of recognition. Maybe they're just trying to scale and they need that, loan to kind of close that gap. But it's definitely something that can be used as collateral. Trademark registrations. Trademark rights can be licensed, sold, transferred when you pass away to your children, your heirs. Lots of different things you can do with intellectual property.
I did not know that.
Yeah, yeah.
Yeah, that is definitely some helpful information. You can get loans off of your trademark.
But
And
if you don't do it, you can't do it. So,
yeah, that's crazy. So what about maintenance? Because you said something about maintenance. What is that? And
yeah.
how do you
So
keep up with that?
exactly. One of the great things about trademarks is you can essentially have trade rights to a trademark for forever. They don't like, there's no time limit, which isn't like, patents or copyrights where there is a time limit there. But the USPTO requires you to continue to submit use. They want to continuously see that you are using it. So, again, once you register your mark, I would recommend working with that same attorney, or if, maybe it's a different attorney, but there are going to be key dates that you'll want to remember, because if you don't, submit that paperwork, your registration, will be canceled effectively. And it's not an easy process to undo. A lot of times, if you've missed those deadlines, you have to start all the way over. And you have to remember, your place in line isn't from 10 years ago when you applied. It's going to be, here and now. So if in the meantime someone applied for something while your mark was dead, theirs probably got through. It got
Oh,
through. Because a dead mark can't be used against an application. So if I, had a company name, didn't keep up with it, it would have been conflicting with your mark. But when that examiner pulls that report, they say, oh, these are dead. They can't cite those marks. They can't say, hey, 10 years ago, 15 years ago, or even whenever someone had this mark and it isn't active anymore. They can only cite those live applications and registrations. So you are allowing people to come in and, maybe start accruing some rights right up
uh-oh.
under your nose. Exactly. So you have to stay up on that maintenance. That's going to be required from the USPTO. You'll apply between your fifth and sixth year, and then again at the ninth year mark, and then it'll be every 10 years
Oh,
thereafter.
okay. So if
You'll
you
have
so if you have a lawyer that you work with, do they remind you? Do you as the lawyer keep track of that and you remind your clients every 5 or 9 years?
Ab right, absolutely. So we'll docket all of those dates. And so I will, we'll remind our clients, some clients who've chosen, they'll handle that part on their own. We won't provide that service. And honestly, understand too that maintaining the registration is separate from acquiring the registration or applying for the registration. So expect to have some type of fees moving forward, not only that you'll owe to the trademark office, but potentially to your lawyer of record for, making sure that your mark is, still in compliance. And making sure the things that you've listed in your registration, you actually are still using them, because the trademark office will audit you and say, hey, you applied for all of these things. Let's see, examples of those things. If you can't produce them, that is not going to be fun for you. Uh,
Uh-oh.
so yeah, you want to make sure, and sometimes it happens. If you have a business, maybe you were providing a product or service, and for whatever reason you don't anymore. Let's remove that, versus continuously saying, "Hey, we're using it," and you're actually not. That's technically fraud on the USPTO. We don't want to do that. So that's another way your attorney can add some value there, making sure you're on the straight and narrow, you have all the documentation you need, you have the examples to show the trademark office as well, and that you're getting all of those things submitted timely, to maintain your trademark portfolio.
Thank you for that information. You have been
Absolutely.
very helpful today with all of these great tips.
That's all I strive to be. I really just want to scream this from the rooftops. I want people to know this information. Again, I feel like so many of us, we form that LLC, or I will say LLCs, that we hear that so much. Everyone knows about an LLC, but when it comes to some of these really important, crucial parts of the business, that's where people tend to fall off. So always happy to answer questions, and help point anyone in the right direction. I'll, again, formally give you my contact information, but anyone who's watching or listening to this, I'd be more than happy to answer any questions that you may have. Then, hopefully set you on the right foot early, on the right path early, versus having to, deal with something costly on the other side. So thank you so much for having me.
Yeah, but before we go, I have one more question to ask you because I didn't really go into the LLC part. When you have an LLC, you can register multiple LLCs under one LLC. Do you recommend that, or should it just be separate?
It It depends. I hate that that's the attorney answer, but it really does depend on what you're doing. So you'll sometimes see people form an LLC just for their intellectual property. It'll, Nike IP Holdings, LLC, for example. It really depends on what you're doing. If it truly is kind of like a parent company, subsidiary type of situation, it makes sense. But at the end of the day, they're going to be separate. Each
Separate.
one is going to be a separate block. So I have some clients who, and some colleagues who, we're attorneys. We have an LLC or a PLC, depending on your state, for our attorney services, but maybe we, offer other services and we form an LLC for that. You want to keep things separate depending on the nature of your services and depending on what type of industry you're in. Some of our industries have, professional and ethical obligations that we have to adhere to, which makes sense to, separate out those LLCs. I don't recommend creating multiple LLCs unless you have, really clear tax counsel, and understand the benefits and the cost behind it. Having more of anything doesn't always mean that it's valuable. And so I have seen some people kind of just, form LLCs. Now you have, 10 companies you have to, pay taxes on, keep up to date because there's, maintenance required for your LLCs. You have reports and all of those things do as well. So unless you talk with an attorney and a CPA and you have a clear, structure on why or plan on why you're going to create multiple LLCs, I would not recommend doing that. Typically, one is going to be enough for your business. Again, asterisk there, depending on what industry you're in, and again, what your long-term goals are as well.
All right. Well, then I'm sure that answered a lot of questions for people.
Good, 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 good.
All right. Well, thank you for joining me here today on the Boss Woman Network podcast. And before we go, what can you say to inspire somebody else, maybe in business, maybe want to become a lawyer, or just in business, period?
Yeah, thank you. Oh, I would say, I know it sounds so cliche, but believe in yourself. If you have an idea, a vision, a goal in your mind, it's not by accident. It was put there, on purpose, and it's because you can achieve it. And so I know, again, it sounds so cliche, but seriously, what's in your mind? is there for a reason. You may feel like I don't have all of the tools right this moment, but start with what you have. We all have something that can help point us in the right direction. And I'll also say, don't feel like you have to go it alone. Find your community. So if you have a dream or you have a vision and you're like, I feel like I'm going to need, I don't have it all. Go look into your community and see who might have those other pieces. I think a lot of times, especially as women business owners, we are like, we're independent, we're super strong, but we don't have to do everything alone. I've honestly found a lot more success when I take a community approach with things. So okay, I can handle this piece, but we're going to need someone to do, the tax side of things, or, this side of things, the marketing, whatever the case may be. Reach out and see how you can collaborate to make your dreams come true. You'll probably reach your goals a lot faster, and you'll probably feel a lot more fulfilled too. Don't feel like you have to do everything alone.
I love it. You heard that. All
Thank you
right.
so much.
Thank you so much for joining me today. You enjoy the rest of your day, and I'm definitely going to be referring business your way.
Thank you so much. I appreciate it. I'll talk to you soon.
Bye.
Bye bye.